Yeah, well, back in 1992, a horrible crime had taken place in a small county called Burleson County, Somerville, Texas. 6 people were murdered, an entire family. They were shot, stabbed, bludgeoned to death. Gasoline was poured all over their bodies, and the house was burned down in an obvious attempt to cover up the crime. And so that was a lot of outrage because this was a small community, and this hadn't happened like that in that community since it existed. So they wanted justice. They wanted whoever done it to pay. As a matter of fact, the mayor came out the next day and said that whoever had done that crime didn't deserve a trial. They should just be caught and hanged. And so that's the way they pursued the case. About a week later, they had a funeral. This funeral, this young man shows up with burns on his body. He became a person of interest to the Texas Rangers, who were also at the funeral. After the funeral, they followed this man home, asked if they could interview him. Took him to the DPS office. For over 14 hours, they interrogated this man. He called my name and said that I was involved in a crime with him. We didn't know that immediately after he lied and they charged him with capital murder, he tried to recant and tell the truth, but they hid all of that. I was picked up the next day, taken to the jail, charged with capital murder, and I ended up spending 18 and a half years of my life fighting for my right to be free as an innocent man. In 2010, I was finally exonerated, and ever since then, I've been out advocating across the globe about our need for criminal justice reform. You can't take the word of someone else and go and disrupt someone else's life without evidence. So what they did is they took this man's lie, and he told them that he lied. They didn't tell nobody that he said that he lied. And they came and they just disrupted my life without any investigation to find out whether that man was telling the truth or not. They just came, picked me up, charged me with capital murder, and then they started trying to build a case.
My name is David Newell. I am a judge on the Court of Criminal Appeals, Place 9. What happens is, what I saw from those cases, or what I see from those cases, is that the prosecutors are firmly convinced that they have the right person. And sometimes when they are firmly and convinced that they have this person, they tend to overlook other pieces of evidence that might take them down a different path. There's just this certainty that they have the right guy. And then once you've done that, there's a real temptation to sort of look only for the things that confirm that you have the right person, that you have the person that you're looking at, not necessarily things that would lead you in another direction.
My name is Juan Roberto Melendez Colon. I was wrongfully convicted and sentenced to death in 1984. I spent 17 years, 8 months, and 1 day in Florida's death row for a crime I did not commit. I was convicted and sentenced to death for first-degree murder and armed robbery. My case was based in the testimony of 2 questionable witnesses. One said that I confessed the crime to him. He implicates a friend of mine in the crime. He gets arrested. He gets interrogated. He makes 15 statements. He incriminates himself in the crime. He gets charged with it. First-degree murder, armed robbery, and they threaten him with the electric chair. So he decided to make a deal with the state. He gets his first-degree murder charge dropped. He gets his armed robbery charge dropped, all the way to accessory after the facts. No more threats to the electric chair. He gets 2 years probation with 2 years he already had. And basically what he said in trial was, I picked him up, took him to the scene of the crime, came an hour and a half later, picked him up again, took him home, don't know what happened to after it happened. And that's the entire case. No physical evidence against me. There's a testimony of 2 questionable witnesses with a criminal record from coast to coast. 2 questionable witnesses that make deals with the state, deals with the prosecutor, and they give leniencies and rewards for their own crimes they commit.
Baylor Wortham, graduate of Baylor Law School, prosecutor with the U.S. Attorney's Office. At the time I was a special assistant United States attorney. When I arrived at the U.S. Attorney's Office, I was assigned a case against a man named Omar Daw. And the type of offense that it included was for the offense of felon in possession of a firearm. And so the facts of Omar's case were laid out as follows. Omar was a resident of Port Arthur, Texas, and on one particular day, a confidential informant called the Port Arthur Police Department and reported that Omar Daw was driving in a vehicle, described the make and model of the vehicle, told the officer where the vehicle would be located, and informed the officer that there was a assault rifle hidden on the back, underneath the back seat compartment of the vehicle, described the location and where it would be found. And so the officer received this information, went to the convenience store that had been that he was told about, found Daw located there in the parking lot, found the vehicle just where the informant said it had been, and contacted Daw, asked Daw for permission to search the vehicle. Daw said, absolutely. Searched the car, looked in the back seat, and lo and behold, just where the informant had said there would be was a SKS assault rifle with obliterated serial number and a banana clip with 15 rounds of ammunition. So Daw was arrested. He had a prior felony conviction. He was charged with being a felon in possession of a firearm. So as the case had progressed, the first hearing that I had with Mr. Daw after he had been indicted was a detention hearing. And he had been appointed the federal public defender. And before the hearing had started, his attorney comes to me, the public defender, and says, well, my client wants to know who the confidential informant is. He's very adamant he wants to know who this person is. At the time, I'm a very new, young prosecutor, and I thought, of course, well, yeah, I bet he does. Wants to find out who it was that had ratted him out, and so we could take out remuneration. So we executed the informant's privilege, as the government has, and so we declined to reveal the identity of the informant at that time. Went through with a detention hearing, and ultimately Mr. Daw was ordered detained. And then a few weeks later, his attorney contacted me and said that his client wished to enter into a plea agreement, and ended up, at the end of the day, after all the sentencing calculations were done, was sentenced to 7 years in federal prison. Now, the break that came in that case actually was several years later. So the informant in Mr. Daw's case was a person by the name of Christopher Thomas. And Christopher Thomas was a individual that was actually being investigated by Port Arthur police on a separate investigation. And it really, the credit goes to an outstanding detective by the name of Paul Arvizo, who looked at the case involving a series of armed robberies of convenience stores in Port Arthur, and knew that Christopher Thomas, who had also served as the informant on that case, had a lot more involvement than just providing facts. And so he went, all the young men that were involved in this robbery case were sentenced to very lengthy sentences. At the time of their arrest, they initially never wanted to talk with the police or talk about anyone else's involvement. So several years later, Detective Arvizo and I reapproached those young men in state prison, and then at that time they told their story how Christopher Thomas not only was involved in the case, that he was the one that had pressured them to actually commit the robberies, provided them the firearms, told them the locations of where to rob, and then actually received a portion of the proceeds after each robbery. And then the time when they finally got caught was based upon Christopher Thomas's tip, where he had instructed them to go rob a convenience store, and then contacted Port Arthur police acting as an informant and stated that there's going to be a robbery at this date, time, and location, and this is the vehicle that's going to be involved in the robbery. And lo and behold, the vehicle shows up, they take them down, all these young men get arrested, and then later sentenced to time in prison. So as we began investigating and talking to those young men, we realized that this CI was essentially creating crime that he was thereafter turning over to the police to try and get credit with the police. We interviewed that other young man who was arrested by Port Arthur police in the robbery. He tells his same story about Christopher Thomas's involvement, that he was directing and providing these guys with the weapons and was receiving cut of the money. And he too also was involved on framing Omar Daw on the gun case. Described the set of facts exactly to a T as the first young man had. And so right then and there we knew that we had a problem, because I sincerely believed these young men, and I knew that I had convicted an innocent man at that point. So, there's no instruction manual on what you do when you get to this point. So, I just said, we'll go to the basics and do what I know how to do, which is get to the truth. So the very first thing I did, obviously, was call the public defender and say, hey, we got a problem. And I called the lawyer that had handled Omar's case and told him the facts that I had discovered. We subpoenaed and brought in the other individuals that had also been involved with Omar Daw's case. And what they all testified to was this set of facts. The night before Daw had been arrested, they had gone to his house and found his car, which was parked in the driveway, broke into the car, and then hid the SKS rifle in the back seat in the compartment. And so to keep the gun from being linked to them, they obliterated the serial numbers. We took the testimony, we went to the judge, with my hat in my hand, I said, Judge, I think we've convicted an innocent man. And we filed a 9-page motion for new trial. The government did, laying out all the facts and saying that the government believed this person had been wrongfully convicted. The court agreed, granted the motion for new trial, and we filed a motion to dismiss. And so when Omar was released from prison, he called me, and initially to thank me. And really, as I told him, I said, look, I owe you an apology. You shouldn't be thanking me. I mean, the system let you down. This was a circumstance where, this should have never happened, and I was apologizing to him. And his basic response is that, well, look, this case didn't happen because of something that you did, but the reason I got out was because of the work that Detective Arvizo and that you did to help clear me, and so I'm grateful for that. And really asking him, well, Omar, why didn't you ask for a trial? If you knew this gun wasn't yours, why did you, agree to plea to it? Why not put up a fight? And his response was very telling. He said, well, I mean, my defense was going to be basically somebody broke into my car the night before and planted the gun there. Who would have believed me? I mean, how believable is that? I just assumed that, it was unfortunate circumstance and that, this was just the reality, that I had to deal with it, and so just do whatever I could to minimize my time. And the benefit of coming from this is the learning experience of never being afraid to take a step back and look at this set of facts and question the things that are brought before you from a CI. If somebody asserts actual innocence, and even if it seems like a ludicrous story, just playing devil's advocate, give them the benefit of the doubt, and then go and take a second look or closer examination of the facts. Because when I went back and re-looked at Omar's case again, after everything that I knew, there were little things that would have tipped me off that something wasn't right. So this case happened in Port Arthur, Texas, where there's always 95% humidity and it's right on the coast. So any type of metal that's exposed rusts. Well, when you looked at the serial numbers that had been obliterated from the gun, the steel was always fresh. So it had to have happened within 24 to 48 hours prior to that gun being recovered. Well, one of the things that the CI had told the officer was that Daw was, quote, involved in some drive-by shootings. And honestly, at the time, there had been a problem with drive-by shootings in Port Arthur. So that was one of the things that got their attention. But the information was provided that this has been something that happened for several months. If that had been the case, then why wasn't that metal rusted? Why was it freshly obliterated from the gun? And so if somebody said that was planted in the car, well, then obliterating the serial numbers prevents somebody from tracing it, and it had been freshly done. That would have actually supported his defense. And so I think the learning takeaway from this point is both from the prosecution and the defense to say, even if somebody presents a defense, no matter how unlikely it may seem, try and give it the benefit of the doubt. Present that to the other side, and then take a step back, try and break down the different aspects of the case, and see if you can, see if their defense actually has merit to it. Because if it does, and that person's actually innocent, then we have the solemn duty to do whatever we can to make sure that that innocent person is not prosecuted, convicted, and sent to prison.
My name is Patricia Cummings, and I am the Chief Prosecutor in the Conviction Integrity Unit here at the Dallas DA's office. And unless there's an agreement, I mean, sometimes you have situations where a prosecutor and a defense attorney will say, I've looked at this and we think that the Brady violation warrants a due process claim, which means they should get a new trial. So sometimes you have agreements that get sent up to the Court of Criminal Appeals. Court of Criminal Appeals still has to say whether or not legally that agreement is sound, but take the agreement out of the equation. If it's something that both sides are arguing about, obviously the court once again is the final arbiter. But what they do, if they ultimately say yes, due process violation, we're reversing, then it is an individual decision of the elected district attorney in that office to decide how do we go from here. And what you hope for is we've seen so much in the last decade in regard to wrongful convictions and the toll they take on not only the person that was wrongfully convicted, but the victim's family, the community in terms of how we look at the criminal justice system. We hope that what we've learned will cause elected DAs to pause and maybe make better decisions as we move forward. I think a lot of what we have to recognize is there has to be a bit of a cultural shift. And that cultural shift has to be that the paramount concern is not always going to be the finality of the decision. It's going to be doing what's right and looking at what justice means, now knowing that we are a system that has gotten it wrong far too often.
When they going to interrogate a suspect, especially in murder cases and homicide cases, they should videotape it, the entire thing, to see if the right of the client is the right of the suspect is not violated, and to see how proper police have done the job. Because when you go by murder, you got to try your best. This go for police. You got to try your best to get the right one, because when you put the wrong one in, what you think the real killer's doing? He's doing more killings.
Neil Berger. I'm a partner at Carrington, Coleman, Sloman, and Blumenthal. I met with Manuel on death row in January of 2009, and I talked to him for about 6 hours on death row. I was the first one from our firm to talk to him, and I left there, and it was sometime in the middle, and I remember thinking, wait a second, is this guy actually innocent? Because he was telling me certain things that went on in the trial and in the case, and it sounded very plausible. It sounded very reasonable what he was telling me. I remember leaving there and calling Lyndon actually immediately after as I'm driving home, being like, you're not going to believe this, but we might have an innocent client here. From the very beginning, and the night that the child was injured, and the police show up and the ambulances show up, they took our client Manuel and his live-in girlfriend to the police station, and immediately someone there had decided that our client did something. They interrogated Manuel, not on videotape, and wrote a long statement in English, which he doesn't. First of all, he doesn't read and write at all. And he definitely doesn't read and write in English. And then they videotaped an interrogation of the girlfriend, where the entire time is, tell us what Manuel did. And when she wouldn't say anything, they would say, why are you protecting him? Did he, and they had a doll, and they were, did he slam the child? Did he hit the child? Why are you protecting him? Tell us what he did. And that was an hour-long interrogation of her, just trying to get her to explain that Manuel did something violently to the child. The momentum, I guess, continued with that, in that eventually they charged both of them with capital murder, but they got a deal with her to testify against Manuel, and she got 10 years. She served 6 and was out. One simple thing to do, I think, is to videotape all interrogations. Because I think his interrogation, if they had videotaped it, and he had a statement that I know he didn't say, I know he didn't read, and he just signed it because he wanted to go. He thought he'd go home if he just because he was talking to him. He was telling the truth to the officer. The officer said, "I've written up what you've said. Sign this." He didn't say what was in that statement. And so if they had videotaped the entire interrogation, I think it would have helped us greatly. I think it would have helped him greatly. And they videotaped her interrogation, mind you. So they had a camera, but they just didn't use it on the person they thought was guilty.
Ideally, you would entrust your defense attorney to find out evidence and find the things that they can point to suggest that you're innocent so they can bring it forward. Bill Allison in the Michael Morton case did a fantastic job of doing that, even preserving things like he did not know that the technology was available that would later exonerate at Michael Morton. He did not, but he preserved the idea and has been complaining, you need to get this. You need to make sure that this bandana is tested. You know, that's what a good attorney does, is that they, even when they recognize that there are shortcomings in, say, the system or their case, or the science hasn't caught up to their ideas, they make sure they preserve that for their clients. And ideally, that's what a defendant would have to rely on his attorney to do something like that. And I mean, that's one of the reasons why ineffective assistance of counsel claims are troubling in the system, is because that's a situation where, and the review of ineffective assistance claims was never really meant to make counsel better. It was always meant to see if, looking at the proceedings, the defendant received a fair trial. But that said, if that's the analysis that courts are engaging in, there's not really a lot of, there's not as many places where you can point to say, well, this is what effective counsel should do. This is how to be effective counsel. It's really more how not to be ineffective. It's not how to be the best attorney you could possibly be. And that comes through a lot of education. And the Texas Criminal Defense Lawyers Association and a lot of criminal defense lawyers associations do a very good job of emphasizing that, the need to educate attorneys so that they are abreast of changes in forensic science and how to zealously represent their client, and how that they can convey how that they can best make the innocence case. But yeah, it is certainly not surprising. I think anyone in a situation where they were wrongfully accused would absolutely want to shout from the rooftops, "I'm innocent! I'm innocent! I can't believe this is happening to me."
Well, the obstacles to overturning a conviction are, as I've explained, there's a presumption that of the validity of a jury verdict. There is inertia. There are resources. Most criminal defendants who have been convicted simply do not have access to good, solid legal representation. They often didn't have access to good representation at the trial level. You know, our legal system is an adversarial system, and sometimes that gets taken much too far. And there are certainly prosecutors who have, over the years, found themselves in such an adversarial system that they forget that they are they are servants of the state, and their job is to do justice, even if that means not getting a conviction.
It was later found out that he had evidence that indicated that I did not commit the crime, but he never turned it into trial defense lawyer. He kept it here. In other words, what they call it, I learned later they call that a Brady rule violation. Withholding exculpatory evidence that indicated that you did not commit the crime. And he will hold 16 documents that could get the real killer. I don't have to go through all this. Later during the case, I realized that I really did not understand what was going in the case, what was going on, and they never gave me an interpreter. So all I remember that I did understood what my defense lawyer was telling me was this. He used to pat me in the back and tell me that everything is going to be all right, that I'm going home. I did understood that part. I should go home. I did not commit the crime. But it turned out to be the wrong. Everything turned out to be in my disadvantage. I lost.
My name is Susan Hawk, and I'm the Dallas County District Attorney. You know, even though a prosecutor may not turn over evidence because they don't know that it's Brady or they don't know that it's mitigating, and it's not done in bad faith, but still, at the end of the day, we're responsible. It doesn't matter whether it's done in bad faith or good faith or how this happened, is that defendant, that's not the test. You have to look at whether the evidence, period, whether it was mitigating, favorable, was Brady, in any way whatsoever, that has to be turned over. So, you know, even though something wasn't turned over because they believed that it wasn't Brady and they weren't doing something that was an intentional act against that particular defendant, it doesn't matter.
The case that I would like to discuss a little bit about in terms of my involvement in a wrongful conviction was Michael Morton's case. I was part of Michael's legal team and actually started working the case long before the big famous DNA fight. Started working the case in 2004. Throughout the time period that I worked on the case, obviously we saw a great evolution in terms of the issues that actually pointed to the cause of the wrongful conviction. At the end of the day, I think everybody who knows anything about the Michael Morton case knows that it was the DNA that ultimately led to the exoneration. But DNA was not the only issue. There were issues regarding prosecutorial misconduct and the failure to disclose Brady material. But something that you don't hear as much about, there were forensic science issues. Specifically, one of the main reasons why Michael was actually convicted in front of the jury back in 1987 involved evidence regarding the autopsy that had been done in the case. And so ultimately, at the time of the exoneration and all the work that took place after the exoneration, a lot was revealed in terms of the accuracy of the information that was put in front of the jury that led to the conviction. So at the end of the day, you look at the Michael Morton case and you certainly see prosecutorial misconduct, as I said. You see forensic science playing a role in it. And then, of course, DNA, which is another scientific issue. But at the time, we weren't in a state where we had the advances that we do now that would have led to being able to establish that the bloody bandana did not have DNA that belonged to Michael. Instead, it belonged to Mark Allen Norwood, who has since been convicted of killing Michael's wife, Christine. When you talk about Michael's case, I think it's really important to differentiate the roles of the prosecutors. What people hear the most of now is the trial prosecutor, whose name was Ken Anderson, who ultimately was held accountable for his actions in the case. The prosecutor that you're referring to is John Bradley, and John Bradley was actually the district attorney in Williamson County that was involved in the post-conviction fight, and that predominantly was a fight over whether or not that bandana should get tested pursuant to a Chapter 64 request for DNA testing. A couple of comments about that. I think if you talk to John Bradley today, he would say, you're right, I was wrong. We should have looked at it, we should have tested it, because what's the downside? Either you're going to find evidence that potentially exonerates, or you're going to find evidence that potentially says we got the right guy. So I think from today's viewpoint, he would agree with you. But as far as looking at legally his position at the time, I have to tell you, legally I don't even think he was right. The argument that the bandana was not part of the crime scene, I just have no idea where that came from, because if you actually look at documents from the original law enforcement investigative file, somebody, a deputy who had actually found the bandana, drew a sketch of the crime scene, and when you look at that sketch of the crime scene, the bandana was found smack dab in the middle of it. So to make the argument that it wasn't part of the crime scene, just as I said, has always puzzled me at best. And let me be fair and clear when I talk about this. The sketch that I'm talking about is literally somebody, you can't really tell now because I didn't see the original, but somebody actually drawing a map and writing an investigative note in regard to what that map constituted, and it was really the area that they had actually patrolled and looked for evidence based on what they thought might have happened at the time Christine Morton was murdered.
So they don't they don't take photographs?
So you got to keep in mind the crime occurred back in 1986. So certainly there were photos of the crime scene, but you got to understand the photos that they had at the time were predominantly in the house where Christine's body was found. The crime scene that I'm describing is the area around the house, the perimeter around the house that they actually investigated, looking for evidence of either the ingress and egress of the person who did this or any physical evidence that might have been left or deposited in the area. And so the bandana was smack dab in the middle of that.
But the bigger thing that you see, the bigger thing I think that you see is actually more along the lines of the prosecutors just not even aware that it's exculpatory at the time they look at it. By and large, that's where many of the cases are, or even worse. Police don't recognize it as exculpatory evidence, so they never give it to the prosecutor in the first place. There's a case called Kyles versus Whitney that recognizes that the duty to turn over Brady evidence isn't just on the prosecutor. It extends to everyone in the prosecutor's team. And that means the police need to know how to find Brady evidence and turn it over, because the prosecutor is going to be tagged for having not turned over this evidence, even if he's not aware of it, because the police officer was aware of it and he just never gave it to him.
My name is Tim Cole, and I'm in private practice in a criminal defense practice in Fort Worth at this point. One thing that should never have any bearing on whether the death penalty is sought in a given case is politics. But that's not the reality. That's not the reality that we live in, because district attorneys are elected officials. And so they have to justify what they do at every 4 years in an election. I began to think about the innocence issue. That probably makes the district attorney the most important person in a death penalty case, because although you're not sitting on the jury, you ultimately don't decide whether this person gets the death penalty. You can certainly decide that they don't by simply not seeking the death penalty in the first place. And so the door is opened by this one person.
There was a time when prosecutors used to walk in the courtroom and they wore the white hat. And things have changed, and I think things have changed, for the better in many ways, because prosecutors are held accountable every single day. And they can't just have all that power, wear the white hat, and everything they say, people just assume is the truth. It's something that we have to prove. Mr. Watkins, the prior administration, had started this conviction integrity unit. We were so blessed in Dallas County to have the evidence to test. We had that evidence available to us to go back and do DNA testing. In many counties, the evidence has been destroyed. I knew there was cases out there that were non-DNA cases that we need to look at and we need to evaluate. And that's why I brought Miss Cummings in, because she worked on the Michael Morton case. She was a defense attorney. She had a completely different perspective. She had the experience that we needed to say, oh, look, okay, these DNA cases, they've already been tested. So we need to take a hard look at some of this other evidence. There might be other junk sciences out there that we need to evaluate and look at these types of cases and make sure that the cases were individuals that were convicted based on the evidence alone, and not based on junk science, not based on recanting witnesses, not based on witnesses that weren't credible at the time, or based on evidence that was not turned over to the defense that should have been.
My name is Michael Morton, and I did 24 years and 7 months to the day in TDC. I was at work when the body was discovered and the police came to my house, and they never contacted me. They investigated, looked at stuff, did the usual murder scene investigation things, but I've learned since through neighbors who were in the house, and they have told me that in the very first hour, before they did any investigations, before they did any interviews or lab tests, or even spoke to me and informed me of my wife's death, the police were looking around and saying, oh, the husband did it, this is easy. And that's how it started.
My name is Christopher Scott. 1987, I was convicted of capital murder. I did 13 years. The crime was a robbery that pretty much went bad, and they actually killed the guy who they was trying to rob. Basically, like 4 hours later, I drove right into a crime scene where they were still looking for the actual individuals, the perpetrators that committed the crime. And I guess we was the first two African-American people they saw, and hey, they chose us too. They actually brought everybody that was laying on the ground with me there that night, but actually put them on a whole total opposite side of the room, so I would be the only one that the victim's wife saw. Walked the lady up to me, the cop did, and pointed at me and said, "This is the man that killed your husband." She agreed and said, "Yes, that's him." She was Hispanic, and when you have people of different races trying to identify of another race, things always go bad. And that's one of the main reasons why wrongful convictions happen.
And that's sort of the thing that I think people don't know. And I think that's something that police officers aren't aware of. Once a police officer or a prosecutor or somebody or a defense attorney too has an idea that they know who did it or what have you, they tend to not look at competing evidence, and they just won't even recognize it. There's a great psychological test that's now being shown to prosecutors. I know because I've seen it at prosecutor training, where it's the gorilla in the room, or the gorilla in the middle, or something. There's a book on it where basically they tell you as part of the test, look for how many passes people are having when they're passing this ball back and forth. And when you take the test, you focus so much on the passing, you don't notice that a person in a gorilla suit comes and stands in between this ring of people passing the ball, stands there, and then leaves. And no one notices it. And that's sort of the thing, is that in hindsight, everyone will go, there's a gorilla. If you know to look for the gorilla, you're going to see this gorilla and you're going to say, that's a gorilla there. You're going to know something's wrong. But when you're dealing with a situation in a heightened case where you are investigating a case or you are prosecuting a case, you may not see that gorilla because you are so convinced that you have the facts, and these facts will point you to that. I mean, there is a case, it turned out to be wrong, but they had evidence that they could use in order to convict Michael Morton. The problem was that there was a lot of evidence they didn't test simply because they were so convinced that the evidence they had painted this one picture that they completely ignored this other evidence. Had they done that, Michael Morton wouldn't have been found guilty. Had they focused on the bandana, or they focused on this other evidence, and they'd been open to these other alternative theories. But that's what happened, is that they were just so locked in their confirmation bias that they just couldn't see what was right in front of them.
One of the gifts that I was given as a young prosecutor, my mentors that I had in my life, the first thing they said to me is, you have to see the big picture. I think where prosecutors can get in trouble is when they get so dialed in that they're not able to see the what's happening around them, or they're not able to see extraneous factors that might come into play, or extenuating circumstances, or favorable evidence that is mitigating in any way towards the defendant, because they're so dialed on believing this individual is guilty. And it's a bias that is dangerous, that you cannot have as a young district attorney, as a DA, as a judge.
So over the course of the first couple of days, they interviewed him, they interviewed the mother, and we have videotape of the interviews of the mother, and it was clear that the entire focus of the investigation was, what did that man do to your child? Why are you protecting him? Why are you standing up for him? Why aren't you telling us what he did? And almost badgering her to that point. The prosecution then worked out a plea agreement with the mother in return for her testifying at trial, and she got a much reduced sentence. She got out from under the possibility of a death sentence.
I think I would tell a new DA or new prosecutor coming up that you need to always be open to another point of view, another perspective, and don't be pressured by whatever the pressure might be into doing something that you don't completely believe is correct or is just or is right. If you're going to be a prosecutor, go into this with the idea that, I could be wrong, and that your job is justice. Your job isn't always to convict. It's to do justice. So you could be wrong. And, question yourself. That would be the advice I would give them, and advice I gave my students is always question yourself. Always make sure that you have the right person.
Get tunnel vision. First and foremost, don't have tunnel vision, because a lot of times prosecutors have tunnel vision, as where if they feel like they got the right man, they're not going out looking for no one else. And in many instances in these cases, a lot of times you captured the wrong guy off the top. But your tunnel vision and feeling like you have the right individual is not leading you to say, well, it may be another guy here that may have committed this crime because this guy is telling me he didn't commit this crime. And you have cops coming to trial saying, these are the individuals that I'm looking for, like in my case. These are the guys that my informant told me committed this crime. These are the guys that MO fits this crime that was happened, not these two guys that's on trial. So once you eliminate tunnel vision from a prosecutor's way of looking at things, the whole system will be a much better place.
If our criminal trials were a little bit more like our civil trials, in that you have everything on the table, this is what we're going to argue about right here, that would change it. Accountability, along with transparency, and even though we have an adversarial system, treating others the way you want to be treated is a really, really good first step. If your case is so weak that you have to cut corners or bend the rules or rely on outrageously emotional pleas to the jury, you may not have a very good case.